Yes, Madam Deputy Registrar, I think we're ready to open the procedure.
Yes, we are, Mr. Justice Witt. Caribbean Court of Justice, appellate jurisdiction on appeal from the Court of Appeal of Belize, monitoring hearing in CCJ appeal BZCV number 2 of 2014 between the Maya Leaders Alliance and 23 other villages and the Attorney General of Belize. The members of this morning's panel are Mr. Justice Witt, presiding judge.
Good morning, all.
Mr. Justice Anderson.
Good morning, Counsel.
And Madam Justice Rajnath-Lee.
Good morning, everyone.
May we have the appearances, please? Thank you.
May it please you, Your Honors. Leslie representing the appellants. In court, we also have some of the leaders of the TAA present, Your Honors.
Sorry, I think I lost her a little bit. But if it's my turn, it's Andrew Marshall together with Ms. Samantha Matut and Mr. Greg Chuck, the respondent.
Okay, thank you. Well, the sound is not exactly what it should be. I hope that will improve. Because the basic thing is that we have to understand what everybody is saying. But I hope that it will get better then. Okay, to start with, we have read the compliance reports, of course, thoroughly. And we have seen, and we think it is something to congratulate the parties for, that you have been achieving some progress at the meeting on the 17th of February, where you also discussed and agreed a time path for further deliberations and further consultation. And so we want to mark that as a very positive step forward. It is clear, we have been monitoring this case for years now, that this is not an easy path to go. And slowly but surely, it seems that we will get at some point to where we need to go. And so I think that we all think that that is a positive development. So we want to be very clear about that will be helpful. There are, of course, issues that is clear from reading the compliance reports. What we want to do is to get some, because some of these areas are not that quite clear, so we want to get some clarification here and there. So for our understanding, and maybe it will be helpful for you too. So I won't, we thought it would not be very helpful to just give you the floor and speak, but let's first go to some of these areas where we think we would need some more information. To start with, let us start with the point of the authority, because some things have been said in the session that was presided by the president last time, but it's not clear to us where we are with the authority. It has been said that there is a case, but it has not been dealt with or taken up by Professor Solorio as the authority. So maybe I should ask the respondent first to see what is exactly the situation around the authority. Mr. Marshallek. Mr. Marshall, you are muted, so.
Sorry.
It happens to us all.
Sorry about that. I'm told I have to hold this closer to my mouth so that you can hear me better.
Yes.
So I'm trying. I understand the Laguna complaint has been referred to Professor Solario, and we're awaiting a response from her.
And so what is the situation? Because she didn't have a contract. Well, she was working without a contract at some point. Can you tell us a little more about that?
Well, she used to work on an annual contract. And
Yeah.
what we decided was, given that there was a long spate of time in which there were no complaints, that it would be better to engage her on a per complaint basis rather than having the annual contracts continue, and there were some difficulties with that. So the way we envisage that it will work is complaint is received, it's referred, and then we can deal with, she can bill us and the payments are made as usual. It's just that we bring away with the annual contracts.
And did she agree to that change?
I'm being told that there has been no further discussions on it. We operated on the basis that she was agreeable to it, but we obviously will have to engage on those discussions if there's an issue. I hadn't realized there was an issue. I thought the Laguna complaint had been referred to her. I'm only now being told that she hasn't responded.
It has been referred to her, but she has not responded.
Correct.
And there was a change made, so she's not working with a contract, a year contract, but on a case-by-case basis.
Correct.
But you are not able to tell us if she agreed to that change.
I am not able to, yes.
Okay, well, that is some kind of some concern, of course, because if she agrees with that, okay, then it would not be that much of an issue. But in fact, it is a different kind of contract then. It's not a year, an annual contract, but it is a different kind of contract. And that has not been put in writing, as I understand it. So that we cannot blame her not to take up the case if she, for example, doesn't agree with that new arrangement, because then she doesn't simply have a contract and she would not be obliged to do anything. When was that issue referred to the authority?
One second, Your Honor. Go ahead.
It was a day in January. Oh, sorry.
February 13th.
February 13th.
February 13th?
February 13th.
Okay. Okay, well, we don't have Professor Solorio today present, I think. Is that correct, Ms. Roberts?
You are correct, Judge. She's not with us today.
Okay. Can you say anything about this, Ms. Mendes?
Yes, thank you, Your Honors. I actually meant to also make the same inquiry to the respondents. Unfortunately, this was an issue that was slightly overlooked in our meeting, but we also are concerned about what is the status of the authority right now, especially in light of the fact that we now have a complaint being lodged by Laguna. We certainly wouldn't want to be lodging complaints into the abyss if we don't have a clear indication of what has been communicated to the authority, what has been agreed upon. On the last occasion, the authority herself made mention of the lack of communication from the respondents. And so we would like some clarity on that. We certainly have not had any communications with the authority. We were also curious to see if she would be present today. So really, we do absolutely need need clarity on this issue in order for us to know how to proceed.
I just want to make the point that, of course, it has always been a very important issue that there should be some system of dealing with disputes that come up, and it took quite a long time to develop the arrangements for what we now call the authority. And so it would not be acceptable to have no dispute settlement arrangement at all. And for that, it is important that first of all, that the authority has agreed to whatever new arrangement concerning her payment, which would not diminish her powers under the arrangement made, and that was an arrangement made also by the government, and so agreed to by the government. So it is quite important that we get some clarity here, and we should get it soon enough. So I will come back to that, but I think we need to get that clarity long before we have another session, as soon as possible. Okay, so that is
Chair,
that point.
Chair,
Yes.
Chair, if I
Sure.
may, just to ask Mr. Marshallek. Mr.
Sure.
Marshallek, as the matter and the progress is made, and I join with the chair in saying how pleased we all are with the hard work that both sides have put into this. But I wanted, Mr. Marshallek, if you could assist as you move forward and put things in place, the role of the authority. How have you all begun talks on what that will look like for the future?
The way we've discussed it cursorily, what has happened in the past, as I understand it, is that when complaints are made to the authority directs these very complaints to the Commissioner for Action. So what has been happening is that the complaints are being received directly by the idea was for the Commissioner to receive it directly and to action them. Yeah. That's us.
Yes, I think I've seen that the Commissioner took some action in earlier cases. But anyway, whatever the procedure is, it should be followed. The authority is the independent person, functionary, and of course she is not there, so she's not in Belize. So it should be the Commissioner probably who will execute whatever directions the authority will give. And I think that happened in the past. But there must be clarity about the procedures and about the position of the authority. I think that is key. So we really need the government to make an effort to deal with that. Miss Mendes?
Yes, Your Honors. I just wanted to add as well that the value of the authority has also evolved to such an extent that she has been also valuable in these proceedings. And so at the last occasion when this issue was raised, we also emphasized that whatever new arrangement is put in place with the authority should also take into account her participation in these proceedings and her valuable guidance that she has given us so far, especially in respect to international human rights standards, in respect of Indigenous rights. And so I just wanted to also emphasize that aspect of the authority's contribution.
Okay,
Chair,
great.
Chair has Mr. Marshall fallen off, or is it just on my screen?
Well, I don't see him.
Justice Fortunately, I'm also not seeing him.
And we're not hearing him either.
We're not hearing him either. I'm not sure. I'll find out from the team. He's coming back. He seems to be coming back in.
Thank you.
You're welcome, Judge.
Sorry, I apologize. We seem to be having some technical difficulties with the normal equipment, so I had to go to our backup. I was explaining that in this case, the complaint went to the commissioner and he actioned it right away, so that even if it goes to the authority, it will come back for the same thing to be done. And as I understand it, those offending actions have already been dealt with. They've stopped. As to why they continued, even in the face of the directions from the commissioner, we're trying to see how we can prevent that from happening again. But the way we were looking at it was that the complaints were very promptly dealt with from our end, so that there would be no need to escalate it to the authority.
Yeah, that is important, because of course in the beginning complaints emerged and nothing was done about them, and that's why the whole arrangement for dispute settlements, and let's put it that way, was because we didn't want to force the Mayas for every little conflict that occurred to have to go to court with all the costs and expenses of that, and so it seemed to us at the time, and that a lot of these conflicts or disputes could easily be addressed if they were addressed quickly and in a pragmatic way. So if that means the only thing is that we need to know, okay, what is the situation now? What is there still a role for the authority, or is it done differently? How is it done differently? We have to know that. But as far as I'm concerned, unless there is a huge change, the authority, we should know whether the authority will be maintained, and that might mean that there might be a different way of dealing with things. That could be possible, but at least there must be still an independent dispute settler, so to speak, and disputes should be settled, should be done with, should be attended to quickly, and those are the ideas that are at the basis of these arrangements. So we still want to know, and we know that you cannot answer that now, but we want to know within a short time, okay, what exactly is the situation, so that we can deal with that, and the Mayas can also know what to expect.
Yes, we agree entirely. Your Honor, we will reach out to Professor Solario and seek to formalize our arrangement. We thought we had one. We need to find out what the position is, if she has objections to that.
Okay.
Clearly, and we can work that out. But our intention is to keep the authority in place, but attempt to deal with the matters more quickly at the commissioner level, so that there's less need to invoke the procedures before the authority.
Yeah, everything that can be addressed quickly and practically is always better than long procedures. But as you said, we don't think that the authority as such could be missed in the picture. So there should be a place for the authority too. Okay, good. So let's quickly go to another item because we don't intend to stay too long. The FPIC protocol. Now,
Chair,
yes.
before we go to the next item, Mr. Marshall, I think we appreciate your commitment to communicating with us as soon as possible in relation to the situation regarding the authority. And of course, you don't have control over all of the imponderables, but can you give us a sort of time frame within which you think it might be reasonable for us to hear back from you as to what the situation is?
Yes, I think I can safely say within the next 2 weeks. We'll reach out immediately and try to get a response.
Excellent. Excellent.
Good.
Thank you.
Thank you.
Okay, FPIC protocol. There seems to be some interesting. What we understand is that the appellants got, or the Maya leaders got the FPIC protocol, which according to the government is finalized on the 4th of January. And it says, Ms. Mendes, that you provided written comments, but no feedback has been received. When did you provide those written comments?
Those comments were provided in May, from May, Your Honors, of last year. Those comments still applies. Those comments still apply. What we received was the finalized version, but the finalized version with the change in the name, but there were not really changes made after we made our proposals. On this point, however, we also want to indicate that, and not to be too premature here, but the Maya land policy as well, it's important to highlight that the Maya land policy itself already seeks to change or to scale back on the application of the protocol as well. So the protocol really continues to be this sort of wavering document that is providing general guidance. Of course, we acknowledge that, but nonetheless, it's certainly, the government says it's finalized, but already in its policy, it's talking about scaling back on that protocol.
Yes, but I also understand, well, this is about oil exploration projects and so forth, correct?
Yes, to some extent it's about that, but there's also generally projects that seek to advance national development, which is a very broad category.
Yes.
On the policy, however, now,
yeah,
it's just to make the point, Your Honor, that the protocol right now it's represented as finalized. But
yes.
Anticipate that if it's not management on the proposed changes that we have communicated.
No.
Ms. Mendes, could you tell us that again? You broke up badly, at least at my end.
Yes.
Apologies, Your Honors. The only point that I'm trying to here is that clear that though the government is present protocol fact. It's still breaking up, Your Honors?
Yes, you're still breaking up.
I'm hearing very clearly.
Perhaps if you took off the video, Ms. Mendes, sometimes we have found
Answer
that
your question. Sure.
sometimes it helps.
Sure. Sure, Your Honors. Able to hear me clearly now?
Well, just speak and we'll tell you.
I'm speaking now. Are you able to
Yes.
hear me?
Yeah.
Yes.
Yes? Okay. So just very quickly, the only point that I was seeking to make is that even though the government presents the protocol as a finalized document, it's clear that there is still, it's not necessarily being treated as such because the policy makes certain changes to the protocol itself. And so even though the government is treating it as such, we would still expect some engagement on the comments that we have made and on the proposals that we have made. And those have been communicated to the government since about May last year.
Okay, so, but apparently the government didn't adopt those remarks that you made and is of the opinion that the draft or that the protocol as it is now is finalized. On the other hand, you're saying that it is also clear that they are, well, that they want to change some parts of that protocol. On the other hand, and this has to do with oil exploration and so on. On the other hand, I understand too that several villages have been approached to get their consent, and some of them have agreed to be consulted about this oil exploration. So in that sense, the protocol is being followed. Is that correct, Ms. Mendes?
The protocol is certainly being referred to and used as a guideline for communities, yes, Your Honor. We are guided by the protocol, but there are instances that in our experience, we have to respond to the actual circumstances on the ground. And so we can confirm, however, that at least in the processes that we have been involved in, we do refer to the protocol, but we do not treat it as a finalized document. It does provide useful guidance to the communities.
Okay. So, Mr. Marshall, could you enlighten us about this particular point?
Yes, Your Honor. Your Honor, the protocol from our perspective has been finalized. I didn't realize we still regarded those comments from all the way back in May as still live. I thought we had dealt with those. There's been correspondences, there's been meetings afterwards. There was a compromise as to the title. There was the printing. So I didn't realize that we were going back there. But the EPIC protocol as it stands and as it's been adopted is an interim measure designed to hold the ring until the legislation is passed. And the policy is intended to provide a basis for instructions for the drafting of the legislation. And of course, it's to be subject to full consultation by everybody. And what we've indicated in the policy is that when the legislation is drafted, we contemplate some adjusting of the circumstances in which the FPIC protocol is to apply. And this arises directly from past experiences in the interim regarding oil exploration, the construction of a road, and the award of significant compensations for the construction of a public road. And we also have issues with providing utilities where compensation is sought for allowing utility poles to sit on certain lands, those kinds of things. So those issues are very live, and we anticipate that they have to be dealt with through a process of consultation and by way of legislation, so that we're signaling, even at this stage, that when the legislation is drafted, we'll expect that these adjustments will be made. But we don't expect to adjust the protocol as it exists and as it applies in this interim measure, in this interim period. It's to apply as it stands.
Yeah, so for example, the government has been, I suppose the oil company has been seeking consultations with the villages where they want to do some oil exploration. Is that correct?
Yes, there have been consultations with a number of villages. Some of them has yielded positive results. And I think in a number of cases, one in particular, there's been no response at all. And the process doesn't seem to want to move anywhere. So we are trying to work all of that out in the interim, but going forward, when legislation is promulgated, we want to conceive of a better way of doing all of this.
Okay. Would that, for example, mean that in that envisaged legislation that these rights of the Mayas would be ignored in certain cases, or would that be too strong?
Yeah, this is one of the things that has caused great differences of opinions. There are a number of ways to look at it, and it certainly needs to be worked out. It's one of the problems we face. From my perspective, if it is that certain rights are taken away, then the Constitution mandates that there be compensation for it. Okay. But there's also been some suggestion by some quarters that even the Constitution itself can be amended. I don't know how that would be worked out. In terms of petroleum, the Constitution was amended some years ago to exclude petroleum rights from the protection afforded by Section 17. So at this stage of the policy, just suggesting it in the policy, it's signaling that these things need to be confronted and dealt with, and we expect some changes from our end. As to exactly what they will be or what form they will take, it's still not quite settled. I wish it were. And it still needs to go through a full consultation process before we arrive at any final position there. In terms of even settling the policy, we've met diverse views on the policy itself, and that has led to some of the delay in even formulating it in the terms that it appears now, which are general terms. It's an issue that has provoked divergent views. Let's put it that way.
Okay, but as long as that legislation is not in existence, you stick to the protocol as it is now.
Correct, and that's why we regard it as final. It's a final to hold the ring while that process takes place. So we're governed by that. It applies to everything in the way it was presented and formulated. But we expect some refinement, some changes, adjustments to make that work better, because we don't think that it has been working as efficiently as it should.
Okay, so it's final for the time being.
Yes, indeed.
Chair, if I may?
Yeah, sure.
Yes. Mr. Marshall, like you spoke about full consultation. Could you let us know what is in mind? And I take it that would be for proposed legislation and any proposed constitutional amendments. Is that right? And let's know what sort of consultation is to be conducted.
Even from the policy level, there'll be wide consultations on it. And I don't know if your honor is aware, but there's a constitutional reform commission currently constituted. Some of these issues might well have to be referred there and dealt with as a part of that as well. But as I said, the thoughts, while ideas have been expressed, no position has been taken one way or the other. Even in terms of the policy, it's still to be finalized from the government end. But we didn't want to appear to be delaying the process unnecessarily. I wanted to signal some of the challenges that are being faced by us from the government's own side in putting a common front forward.
So Mr. Marshall, just to go back to the consultation, then I take it that will be with all the people of Belize then, not simply the appellants before us. Is that what Correct. Is intended? I'm not sure.
Yes, there will be, I think the release from the government committed to wider consultations. Certainly it's been submitted to the appellants and there will be particular consultations with them. But I think comments will also be invited from the wider public and other stakeholders.
Mm-hmm. Yeah, Mr. Marshak, I just wanted to, I think I didn't want to raise it, but I think it'd be appropriate if you're speaking about wider consultation to speak about a sensitization of all the peoples of Belize as to the importance of the recognition of indigenous rights, and in particular, the rights of the Maya of Belize. I just feel that having regard to some of the things we read today, that sensitization, I don't want to say training because that's a different kettle of fish, that would involve a lot more money, but a sensitization, whether by way of public campaign or just as part of the consultation process, that persons will understand that persons the appellants are not begging, they're not getting something for free. They're entitled by way of international law, by way of the Constitution, and there is a consent order in place that both parties are working together to bring to pass. I don't know if you follow me at all, Mr. Marshalik.
Yes, I do. I mean, it's a very live issue, and it's something we've encountered even in terms of getting the policy settled and getting people to focus on exactly what the implications and understand the need for its formulation in the terms that it was proposed. There is a need for sensitization. We involved in the case and in the ministry are sensitive to it and are very familiar with it. When you step out, it's not the same. And certainly there's a need to get a wider cross section of Belize understanding exactly what is happening here. That's very true, and I think it's a necessary part of the process.
Yeah.
Yes, I think Professor Solorum or someone else on the last occasion made the point that the world was looking to see how well Belize did this. And of course, there are other people who've been through it, New Zealand, Australia, Canada, and so there can always be assistance. And I'm sure somehow, Mr. Marshall, given the government of Belize may be able to get funding to do certain things, because these are important and important to a lot of people around the world. Anyway, thank you, Chair.
Yes. Yeah, so taking a next point now. I read, I think this was in the compliance report of the appellants, about a section 6D in the revised roadmap, that there was agreement between the parties that the revised roadmap should be amended to make clear that the Maya villages are not required to accept the continued occupation of third parties on Maya land. It was agreed in the language be amended to reflect that Maya villages had the right to consent or refuse to consent to continued occupation. That remark was made. I want to ask Mr. Marshall if that is correct.
Yes, that's one of the other sensitive issues that have come up in the formulation of the policy. And what I see happening is that the roadmap in its formulation is usurping some of the policy role and function. Because as far as we're concerned, the roadmap is about setting the scheduling implementation of what the policy is. So I think those differences arise out of the fact that the policy itself regarding that has not been settled. As I understand it, there's an ongoing effort to identify all these third-party claims. And once they're identified and the extent of it is known, then, and we come up with a way of dealing with it, it's either the case that the communal Maya land rights in these lands are respected and these third-party landowners need to move on and compensated, or vice versa. That's one of the thorny issues that remains to be confronted, and in respect of which there's been no happy resolution, and I suspect there never will be. But yes, some sort of decision needs to be made as to whether or not the rights would be asserted in respect of these properties or not. And I think that can start with an indication from the Mayan communities affected as to whether they wish to continue to assert those rights or not in relation to those particular parcels.
Yes, but you so you confirm that there was agreement on that particular formulation? Because that is what is stated in the compliance report of the appellants, but I didn't see a reaction to that. So I just want to verify if that was indeed agreed.
Yes, there was, as I remember it, and Ms. Mendes can correct me if I'm wrong, there was an adjustment to some language in a statement. I think some words were changed that changed a nuanced meaning. So from my perspective, it wasn't very significant, but I appreciate why they considered it important. And I think the change in language has been proposed. I think we received correspondence this morning so that the statement, the agreement was essentially in those terms, but the language used to express it is being adjusted. And that's what I understood was happening here.
Okay.
So it wasn't really a disagreement as to what was to happen. It was really a disagreement as to how it ought properly to be expressed.
Okay, Mr. Mendes? Ms. Mendes, could you?
Sorry, before you go to Ms. Mendes, just
Sure.
a question for Mr. Marshalik. I noticed one or two places in the compliance report, there's a reference to the possibility of a constitutional amendment to deal with the adverse effects of the FPIC or the draft policy. And I wasn't quite sure what you had in mind. Is it what you just mentioned there about compensating persons who will perhaps have to leave their present location in the Mayan communities, or are you thinking of other things as well?
Yes, that and other things, because some of the lands affected are also reserves. And there are issues as to how you're going to harmonize how that works. But yes, that is one of the things. And in the interim, there was a claim that went forward through the court system arising out of, there was a significant compensation award made in favor of one village for government having constructed a road. And those are the kinds of considerations that have fed into that policy consideration, that policy formulation.
Yes, it seems as if there's going to be the need to reconcile and to bring into harmony quite a few pieces of legislation in relation to this project. You have mentioned some, and they're very, very important. It could be quite intractable, I imagine. But it's a very complex process, and I don't think we should underestimate the degree of difficulty that will be involved in trying to carry forward the consent order against the background of the kind of legislative constitutional landscape that you have in Belize.
Yes. So this inclusion in the policy that constitutional change will also be considered was to give the policy a little more flexibility in how it's formulated.
Mr. Marshall, I get the impression that Ms. Mendes is not with us anymore.
Oh, sorry.
She seems to be back, Chair.
Is she back? Ms. Mendes, are you back?
As I see her on the screen, but she is mute.
I think she was trying to get back in judges, and
okay.
I let her in, and I'm not sure what's happening now.
She
Justice
will
Witt,
be.
Do you wish to take a few minutes to let the team see whether we can locate her and see what's happening?
Yes, because it wouldn't work if one of the parties is one of council is not here.
Correct.
So what do you suggest? A few minutes?
Just that we stand down for about 7 minutes or so. Is that all right?
Unless we are back earlier. So
if we are back earlier, I will alert you, Judge. I will alert you.
Yeah, we will be standby, so you will just announce that everybody is back, and then we can come on.
Yes, great. Thank you.
Yeah?
Thank you, Judge. Thank you, judges. Thank you, Council. Resumes. Thank you.
Yeah, we will resume. Okay. Yes. So, Mr. Marshallek, you were explaining something.
Yes, I'm not sure where exactly she dropped off, but I'll just recap. The issue of third-party landowners and third-party rights, and the statement in the road not concerns whether or not the villages will be given an opportunity to state whether they want these people to remain or not, whether they'll be, as I understand it, asserting the customary mile and tenure in respect of those lands, or respecting or accepting that these have been alienated to third parties for a long time and they ought to keep them. Because some of this goes back decades. Yes, that election has to be made. And a part of it's a very thorny issue, and decisions will have to be made as to how these competing claims are to be harmonized, if they can at all, or how they're to otherwise be dealt with. And this brings in to the discussion possible compensation. And that's why the policy is formulated in those terms. But it's also expressed in the policy that the government will consider a constitutional amendment in order to limit some of the financial consequences of the decisions that will have to be made. And again, no decision is yet made. The policy of the government is to seek to harmonize these interests. And that's a tall order, but that's as far as it goes just now. So how exactly that will be achieved is one of the things that still needs to be worked out.
Yes, what I understand is that not a clear position yet, that it's all under consideration, and that there are probably even diverting opinions in the bosom of the government, how to exactly deal with this, which is indeed not an issue, a very easy issue. So, okay, so that makes it clear. Ms. Mendes, just a reaction on what was being said?
Yes, Your Honors. Can you hear me?
Yes.
Yes, Your Honors. At our February meeting, what we indicated or what we raised was the language around that section that seemed to suggest that what was being proposed was that the communities would be under an obligation to confirm their agreement with the continuing occupation. Our understanding is that my learned friends on the other side agree that we perhaps could clarify what that means is that the communities would have the opportunity to elect, but certainly indicate whether or not they would be in agreement with their continuing occupation. If we look at that revised roadmap, it makes sense that it's an election, Your Honors, because there is envisaged within the process a dispute resolution for third-party rights against Maya land rights. So there is envisioned a dispute resolution mechanism that would deal with the competing interests. So there's no doubt on our part that certainly there are competing interests which need to be resolved. And the idea is to set forth a mechanism through which these claims would be resolved. And that, of course, would be informed by international standards and other best practices that have been used across the world.
Okay, so I think we can leave this to your consultation process that you have set out for the coming time to see how that is worked out in the text. If I may, we can go to another item, which is the delimitation of boundaries. Apparently, well, there was some indication that the certain villages complained that delimitation of boundaries took place near their own borders without being well, kind of being ignored. But I think, Ms. Mendes, you said there's no such thing. And in fact, there is a mechanism, the DPM, which can be used in such a case, which is the delimitation principles and methodologies. And you suggested that the participation of the Ministry of Natural Resources is important, and that the parties have agreed to hold a working session on the DPM to apprise officials, including the ministry's CEO. Is that correct, Mr. Mendes?
Indeed, Your Honors. You see, these are not new complaints or issues that have been raised by neighboring communities. One of the challenges that we have faced is that there has not been a deliberate effort on the part of representatives of the government to really take on board the DPM and sensitize people, as well as any member of any community that comes to them with any questions, that there is an established process. What that creates is a lot of anxiety among persons and as well as neighboring villages that could foresee that the demarcation of boundaries is likely to affect them. So one of the things that we raised at the meeting is to say, listen, the revised roadmap creates even further confusion in the sense that it seems to set out even an alternative process from the DPM, which has been developed by the parties jointly, albeit under the previous administration, but it was in fact concluded. And it has been implemented indeed by 25 communities right now is implementing it. That being said, we are open and we have always been open to hearing from our learned friends what are any questions they might have, as well as any forms in which that document can be improved. Now, thankfully, we were able to agree on a working session that where we could tackle those issues head on and we could finally come to some agreement or consensus on the DPM and its application. Because one of the challenges is that we have always been unsure, or rather in practice, government officials, unfortunately, have not been explicitly referring to the DPM.
Okay, but apparently during your meeting, there was some progress made, and that the parties agreed to hold that working session on this particular dispute settlement. You say it has been used in the past too, correct? So
DPM, yes, Your Honor.
Yeah, so villages should be aware of that procedure. But
Indeed,
okay.
There are times that villages believe that they will be kept out of the process, and what we have been attempting to emphasize is that there are procedures that provide for their inclusion, both non-Maya villages as well as a special procedure for other indigenous groups such as the Karinagu.
Okay. Yes, Mr. Marchalik, anything you want to add to this?
No, Your Honor, we've committed to try to work it out with relevant authorities, and we believe, we're confident we'll be able to come to a better understanding among the people who implement these things as to how it should work. So I'd love to give that a chance.
Great. Then there was an issue about legislation and village bylaws, Maya Land Registry Office. That is the legislative drafting component of the revised roadmap. Apparently, the appellants raised issues in a letter dated the 31st of May 2022, but these have not been considered. So the question is, are they going to be considered, Mr. Marshalik?
Yes, Your Honor. As I said, indicated before, I think the roadmap was really usurping the role of the policy in terms of how it's formulated. So it has ventured into policy territory. And these are matters that we've sought to deal with in the policy, so that once the policy is settled, we go back to the roadmap and set the schedule for implementation. These are some of the issues that have come up in our considerations in formulating the revised draft policy that has been put forward, in respect of which the appellants are being consulted. I don't think decisions have been made on these things one way or the other at this stage. We were really focused on more basic more basic policy considerations on how to go forward, rather than fleshing out these details. So it's not details that we have focused on just yet.
Yeah, you're saying that, okay, first we need to have the basic policy before we can work it out in legislative components.
Yes. That's the issue.
Yeah, but it's not that they will be ignored, but that they will come. They will be dealt with when there is a clear policy, and that is still under in progress, so to speak, under construction.
Correct.
Your Honor,
sorry.
Yeah, sure. Yeah, Ms. Mendes.
Apologies. I just wanted to clarify that point, if I may. Our understanding at the meeting, and if we look at some of the very concrete steps that we were able to agree upon, and that provide a sort of very systematic way of addressing these issues, what the parties agreed was that on our end, even though we had already communicated our positions in May, we would reiterate our position and provide that in writing to my learned friends. We did that today, this morning. After that, my learned friends at that meeting undertook that they would respond to the comments that we have made with respect to the roadmap within, I believe, 2 weeks or 3 weeks. And so my understanding is not that we are waiting on agreeing on the policy or finalizing the policy, but rather that we are going to try to come to an agreement simultaneously on these issues. And I want to emphasize why that's important. For us, Your Honors, and I can also imagine for the government or anybody trying to seek funds for the implementation of this process, of the consent order, we certainly need to be able to provide a roadmap with some foreseeability, predictability on how this consent order would be implemented and where the funds would be going. And so that's why it's important for us to be able to agree on a general skeleton, for instance, of how we will be implementing the consent order together. And so what our expectation is that we would be hearing from the respondents on these issues within 2 to 3 weeks' time. And so we would assume that they would give serious consideration to what we have communicated, especially in light of the fact that we have communicated this since May last year.
Okay, well, I suppose this will be on your agenda for the meetings that are scheduled. So we will have to wait and see how that will go. Once more, I think by agreeing to that schedule of meetings and so forth, much progress is already been made, has already been made, because this was kind of lacking in the past, we are hopeful that that the continuing discussions will lead to results. As everybody is aware of, this is not a very easy thing to do, but at least there is progress being made. So I think that is a very good thing. Of course, in your compliance report, you made some remarks about derogatory statements made by a minister. We don't want to get into that too much. I would simply say we can certainly agree that those remarks were not helpful, but let me leave it at that. And I think I hark back to what Justice Ratchnotly was saying, that it is necessary to make people aware of the importance of this whole project. And that doesn't mean, and that is also stated in the consent order, it doesn't mean that a state within a state has been created. It's not that, but it is about rights that have been acknowledged internationally and also now under the consent order. And so it has to be executed in one way or the other, of course, in a way that is in compliance with the whole background of this issue. So that is what is to happen.
Your Honor.
Yes.
If I may, I won't belabor this point.
Mm-hmm.
We have made
you have made your point.
Known,
yes.
But I do wish to emphasize just very quickly, because it's a very serious concern for us. As we highlighted, it's not only that it's not helpful to the process. Of course, it's not helpful to the process. It definitely agitates a lot of social anxieties that exist. But we do want to emphasize that for us, and we want to do this we want to inform the court. We must inform the court, Your Honors, that for us it is also dangerous. It's dangerous for the Maya people and for their representatives. I count myself in that group as the legal representative for the Maya people. that there is a risk, that it is potentially insightful of persons that have these anxieties that have not been addressed. And Your Honors, we must emphasize that these statements, or at least what we have tried to communicate to the government, we're not being alarmist. I think that these are rational fears and concerns that we have that might in fact disincentivize us meaning again the representatives, the leaders, and as well the Maya people from pursuing their rights. And they might expose us to some harassment as well as violence. Often we think that it won't happen in our countries, but then it happens, especially when we're not being responsible as high-ranking members of governments with the statements that we make. So again, it's not that I want to belabor it, but I need to communicate and I guess to request from the government that these statements and that our perspective and experience on the ground be taken seriously. Because again, I say that these fears are indeed rational. We work on the ground. We work in Toledo, which is the farthest district from the central government, which is also the most under-resourced district, as well as the fact that we work in remote communities. And we do hope that these matters are in fact taken seriously and are not dismissed as just being alarmist. Thank you for that opportunity, Your Honors.
Okay, well, you made your point. Is there anything you want to say, Mr. Marshallek, on this point?
I'm not sure that there's anything useful I can add. In terms of fears, they're all over the place. Risk, they're all over the place. So there are fears, real fears there on both sides of the issue, and there are risks to doing what we do.
Yes.
That is what it is.
And that's why it's important what Justice Rajanathan was saying, that that everything should be done to make people aware in every corner of society that this is not something that being nice to the Maya people or something. This is simply about rights that exist that are not easy to work out in balancing all the interests that exist. So it is therefore a process that takes time and will not be an easy road to walk, but nevertheless it has to be done. And people should be aware of that in every part of the country, up to the highest regions of society. This is what has to be done, and there should not be any fear for violence. I know that nowadays it's quite spread over the world that disagreements end up with violence or threats, but it has to be made very clear that there is no place for that. This is a serious process which needs to be implemented and needs to be complied with and needs to be ended at some point. And there will always be a situation where some are less happy than others, but this is what it is to live in a society. And we have to solve those problems in a democratic way according to the rule of law. That is simply said what needs to be done. Okay, so let's, I think we discussed all the issues that came up in the compliance reports. Or is there something else, Ms. Mendes, that we did not touch on?
No, Your Honors, I believe that we've touched on everything. I do want to just reiterate what Your Honors have indicated, that for us, certainly the meeting held in February was certainly a productive meeting, and in our view goes to show some what we have been saying all along, that for us in-person meetings can really render positive results so long as we come with an open mind and ready to listen to one another. Thankfully, we have been able to agree on the steps, concrete steps to be taken. That does not mean that we do not foresee that, for instance, the policy will certainly be a site of intense debate. And we just hope that the respondents again continue to come, and we certainly undertake to come with openness, to listen to one another and in good faith, and that we remain committed to the spirit and to the text of the consent order, bearing in mind that this is a process grounded in litigation, and it's a process that should be guided by the Constitution and not only the desires of Parliament or the positions that ministers take, but rather bearing in mind constitutional standards as well as international human rights standards when we are engaging in these discussions.
Thank you. Mr. Marshallek, is there anything that we haven't mentioned or something that you want to bring forward?
No, Your Honor.
Okay. Okay, so, well, we got your clear the schedule of the meetings that are planned in March and April. And we want to leave that as it should in your hands, of course, to make any further progress as possible. We do want to follow you very narrowly, so we would want to have a next session not too long after your final meeting, well, not final meeting, but in this schedule, which would be, let me see, on the 28th of April. So we would want to have a compliance report, or at least a report of what is happening. Let's say around mid-May. Mid-May, yeah. Mm-hmm. And then have a meeting on the 6th or 7th of June, another compliance session.
That works for us, Your Honors.
Yes. And of course, we will get within 2 weeks from now from the government further clarification of the position of the authority. Mr. Marshallek, is that fine with you?
Yes, Your Honor.
Chair, did we want a joint report from the parties or separate reports? I'm not certain. And the 15th of May is a Monday, might be a good day.
Yeah, that might be a good day. So yeah, well, the idea is always that if you can produce a report together, that would be the preference. If not, then at least we should have a report from both sides. So that would be it. And we will understand that, of course, that it would be quite surprising if you solved all the problems that exist in May, but or in April, but at least that we can see what is being discussed, what are the issues still to be resolved, what are you working on, etc., etc. So those are kinds of things we really need to know. So let's say the 15th of May, we want to have those reports, either a joint one or separate ones, and then either 6th or 7th of June. Is there any preference, Ms. Mendens, for either date?
No, Your Honors. Either works.
Mr. Marshallek?
It's 7th, Your Honor.
7th of June?
Yes.
Okay. Well, that works for us too. So we will we will schedule the next session on the 7th of June at 11 o'clock Trinidad and Tobago time, which will be 9 o'clock, I think 9 o'clock Belize time. Depending on the report that report you will send in 2 weeks, within 2 weeks, about the status of the authority. Depending on the content of that, we will see if we will also invite Professor Solorio for the next session. So that report about the authority, we could get that not later than the 14th of March. Correct, Mr. Marshalik? Is that all right?
Yes, Your Honor.
Okay, so we will get your report on the authority on the 14th of March, not later than. We will get the reports, let's say the compliance reports, either joint or separate, on the 15th of May. And we will have another hearing on the 7th of June at 11 o'clock Trinidad and Tobago time, or 9 o'clock Belize time. And depending on the content of the report, we will invite Professor Solorio for that session also. I think that would conclude our session for today, unless my colleagues have anything to ask or to add. If not,
No, Chair. Thank you.
No.
Thank you, Chair. No, nothing from me. Thank you.
Okay, so then we can conclude, Madam Deputy Registrar. Could you close off?
Thank you, judges and counsel, for your patience today with all the technical difficulties. So thank you, Justice Witt. Thank you, Mr. Justice Anderson. Thank you, Madam Justice Rajnath. Thank you, counsel. And thank you to the staff of the Caribbean Court of Justice. This court now stands adjourned. Good day to all. Thank you very much.
Obliged.
Thank you. Good day.